case of proof of the causality, Verursachung, Kausalität, Yinguo, Guanqi. This is a main problem in environmental civil liability, so there has to be proven that a linkage, that a connection exists between a certain damage and a certain action of the accused. And when we once more have a look at comparative law and look how the situation is in Germany, we can find that the burden of proof, so the one that has to prove, the burden of proof, Beweislast, 举证责任, rests with the accused, the Begaoren. And in Chinese law, this is the opposite, at least until July 2010. So the burden of proof rests with the plaintiff, Kläger, Yuan Gao. And this is only the situation as the law stipulates it, but there exists a so-called 意见, so an opinion of the Chinese High Court of 1992, and this opinion says that the burden of proof rests with the accused. So Häuser, this is taken from this book of Häuser here, Häuser and de Graaf, in the article of Häuser himself, and so we have to think that at least since 1992 this burden of proof rests actually in practice with the accused. But actually this is already out of date, because since July 2010 we see this new tort law, and this stipulates that the burden of proof rests with the accused. So the most important innovation of this new tort law is what I just told you, or only with respect to environmental law. The most important innovation. So this so-called reversal of the burden of proof, Beweislastumkehr, 举证责任倒置 in Chinese. So this 倒置 means reversal here. And yes, from that time on, so the accused facility, for instance, is forced to prove that it has not polluted the environment and caused the respective damage. Another important issue is that with respect to compensation disputes, I just told you on another slide that there exist three directions of environmental civil liability. So first, omission; second, compensation; third, reinstatement. And with respect to compensation, we have two possibilities how this is enforced. And possibility one is a two-step approach, and possibility two, only one-step approach. So in possibility one we can go, and this is actually in practice very common in China, first go through mediation, Schlichtung, 调解. And in a second step, if the first step fails, we can go through civil procedure, Zivilprozess, 民事诉讼. And the second possibility is, as I just told you, only a one-step approach, so directly go to civil procedure. And this also means that the mediation step can be left out, and this is a form of so-called voluntary mediation. In China there exist two kinds of mediation. The first is voluntary mediation, and the other one is legally compulsory mediation, so cases in which a mediation has to be done. And with respect to environmental law, we can say that we have this form of voluntary mediation. And another important issue with respect to environmental law or environmental civil liability is special proceeding form. Just look once more that you also can see it. And this is a special proceeding form of what Häuser once more calls procuration procedure, Vertretungsprozess. Or actually it's not what Häuser calls it, it's written into the law and Häuser just repeats it. Vertretungsprozess, divergence,诉讼. So this is something like a class, or it's actually just a class action, Sammelklage, Gruppenklage, Massenklage. And other terms in German, in Chinese it's 集团诉讼 or 集体诉讼. So this means that one or several persons file a lawsuit in the name of all injured persons, and we can find this not only in the field of the environment, but also in other so-called case groups, Fallgruppen Analysen. Such class actions exist, for instance, in the field of product quality, and also in case of labor law. So for instance, in cases when the wages are not paid, and also other cases. And the background of this special procedure form is often an infringement on collective legal objects. So just leaving this environmental field and think about this issue of product quality, this is also something like a collective legal object, or this has to do with the collective legal object of technical safety, as I said earlier. So every one of us can be injured by a certain product that is not safe. So here we have a possible infringement, and the legal object, Rechtsgut, here we have this legal object of environment or nature or landscape, and as a consequence of such an infringement on a collective object, we also have a collective action, of course, so a class action. And this kind of procedure also has certain advantages, and here we have first to say that it simplifies the proceeding. So simplification of the proceeding, Verfahrensvereinfachung, and this is not only in the interest of the plaintiff, but also in the interest of the state, that has not to deal, or in the interest of the courts at least, that has not to deal with a huge amount of singular cases with the same or at least a singular background, and instead such cases are merged together, are brought together to save money and simplify the procedure. So you see that through such a fusion of cases, the state or the courts can save capacities can save money, and it's not only in the interest of the plaintiffs or the clients, yes, the plaintiffs. And the second advantage is that emphasis is put on the respective issue. A third advantage, that legal costs, Prozesskosten,诉讼费用, are decreased. And yes, by the way, this decreasing of the legal costs also increases the probability that people will file a lawsuit, because the costs are lower, of course. And a final advantage is that there exists also a higher chance to get media coverage, of course, because many people are part of such a class action, and yes, this is often also a big issue in media coverages. And yes, if you have watched my other video on YouTube, so the video about environmental law, if you have not watched it yet, I recommend you to watch it. Then you know about the importance the media play in legal enforcement in today's China. So if you have not watched it, just watch it. And nevertheless, there exist